Hello, welcome to this video on the implications for lawyers now that the Article 50 notice has been served by the UK government. My name is Jim Leason. I'm VP of Market Development and Strategy for the Thomson Reuters Legal UK and Ireland business. I'm going to be covering today what now happens as a result of the notice having been served, the types of things that lawyers should be thinking about and doing, and the products and services that Thomson Reuters can provide to support lawyers in these activities. Now that Article 50 has been triggered, nothing fundamentally changes in the UK, except we've kicked off a process for leaving the European Union, and we have 2 years to negotiate both the arrangements for the UK pulling itself out of the European Union, but also 2 years to negotiate the trading relationship that the UK wants to have with the European Union beyond the date at which we leave. The other thing that changes is we have to start thinking about the trading relationships that the UK wants to have with other countries outside of the European Union that previously it hasn't had to have a trade deal with because it's relied on trade deals that the European Union has negotiated on its behalf. So unfortunately, we will live for some time with the uncertainty as to what the position of UK law will be on the day of Brexit, and also what the final deal will be with the European Union. And there are several reasons for that. If we start at what UK law will be on the day of Brexit, the government has got to go through a process of understanding the body of European law that applies to the UK. And that's complicated not just because of the European legislative statutes, but also because European law includes both case law, but also regulatory decisions made by agencies. So the first thing that they've got to do is understand what is the legislation. They've then got to bring that European legislation into the UK statute book. That's a very complicated process dealing with thousands of legislative European instruments. Secondly, as we're in that negotiation up until the Brexit date, if we're wanting a free trade relationship in some areas of business, we may have to accept that some of those European laws will have to continue. So there will be a bit of toing and froing in the run-up to that date as to what the UK law will look like. So thirdly, unhelpfully, we've got European elections this year, which may shape the political climate of France and Germany, but practically it means that the European Union will not be ready to negotiate with the UK until after the German elections at the end of September. So we won't start to see what the negotiating positions start to look like and what the big issues of the trading relationship are going to be until, at least October, November and December in 2017. And the one thing that we won't know until we get into the negotiations is the extent to which the European Union is willing to allow for a transition period and the extent to that transition period, which may provide the government with more time to finalise some of these arrangements that perhaps won't have been agreed at the time of the Brexit day. For lawyers, it's going to be a very interesting period over the next 2 years. If we take the government lawyer space, this is a process that the UK hasn't seen before, with the scale of legislation that's got to be brought onto the UK statute book, and at the same time as making decisions on whether that legislation ought to change at that same time. So for government lawyers advising ministers, they are going to be very, very busy. Coupled with lawyers supporting the trade negotiation process and perhaps supporting discussions with other countries that the UK wishes to enter into trading relationships with beyond the date that we leave the European Union. For in-house lawyers, I suspect it may be a relatively frustrating time for them as they have to manage the expectations of their clients internally within the business in making some complex risk-based decisions about a scenario at a point in time that they will not be able to give the certainty to their clients about. And so there may be decisions that are made which ultimately we will find out perhaps didn't need to be made because a negotiated position was agreed. And so businesses will need to make decisions on whether they react before the Brexit date and make changes to the way that they operate as a business, which may include setting up operations in the European Union to give them the certainty that they will be able to continue to operate and trade within the European Union. But it may also mean that some businesses decide to wait it out until the certainty is provided. For the private practice lawyers, I suspect it's going to be boon time as you know, their corporate clients turn to them to help them understand what they should be doing. On one level, you've got the sort of regulated businesses that operate on a passporting scheme through Europe. The main example being financial services, where the extent to which those businesses can continue to operate as they have done before, based on regulation in the UK, trading through Europe, will depend on whether the government's able to continue to agree a deal that allows them to continue that passporting mechanism, or some other sort of free trade arrangement. We've already seen banks make public statements about their desire to shift operations into cities like Paris, Frankfurt and Dublin. And that indicates, I think, that we will see businesses look to establish operations within the European Union to give themselves the certainty that they can continue to operate beyond the day of Brexit and not rely on perhaps a negotiated deal between now and then. There are other practice areas like competition law where the lawyers are advising on effectively European law, taking cases and matters to European agencies, where the ability to represent clients and appear at these agencies will be lost just because the UK is no longer a member of the European Union. And importantly for clients, losing that right of audience in front of these agencies also loses the right and the benefit to legal professional privilege. So the ability to advise clients who are preparing for these hearings may be lost as well. So again, depending on the extent to which the government's able to agree a deal that allows lawyers to continue to represent clients will depend on whether that continues. And again, we're seeing law firms already have lawyers requalify in Dublin to ensure that those lawyers have the ability to continue to represent clients and benefit from legal professional privilege based on Irish qualifications. The European Union will continue to legislate and pass laws between now and the date of Brexit and beyond. The extent to which we need to worry about European legislation that's passed between now and Brexit, but which comes into force after the date of Brexit, will really depend on the extent to which the UK accepts that it has to comply with European legislation as a concession for maintaining free movement of trading with the European Union. And perhaps that may apply in particular sectors and not broadly across the board. What businesses cannot do is take the eye off the ball in terms of compliance with legislation that has already been passed and which comes into force between now and the date of Brexit, because that legislation will be part of UK law on the day of Brexit. A good example of that is the General Data Protection Regulation, which is a significant change to the compliance regime for data privacy, and which many businesses have been investing significantly in to prepare for and comply with when it comes into force in 2018. And now, of course, there's possibilities that the government could decide to make changes to these laws that come into force between now and Brexit because they want to change the UK legislation. But I think in relation to the General Data Protection Regulation, if businesses want to continue to provide their services into the European Union after the day of Brexit, we should expect to have to comply with the level of standards of the General Data Protection Regulation. So I don't think there's much risk in continuing to prepare for and comply with it. So there's obviously lots of things that lawyers are going to be asked to do in the run-up to Brexit and will have to do to enable their businesses to continue operating in the way that the business wants to operate. And perhaps lawyers are not going to get all of the resources that they ask for to really help prepare them for this. And so now is is a good time to be thinking about the tools that you've got to help you with this, to really ensure that you're as efficient as you can be in terms of preparation. So this could be as simple as using information services like Practical Law and Westlaw, which are authoritative sources that you can rely on and which will provide you with a comprehensive view of the position as it is now, with some guidance as to what changes are being proposed and what perhaps that's going to mean for you as a lawyer. So having services that you can go to without having to check multiple sources is going to be a smart thing to have. Another area where there's a significant burden on lawyers is in the area of contracting, where lawyers can easily find that they're working with out-of-date precedents that refer to legislation which has become obsolete or which is going to change, and perhaps where there could be contractual provisions which may need to change as a result of the UK leaving the European Union. So having reference to an up-to-date precedent suite which includes provisions that anticipate the event of Brexit and allow the contracting parties to come back to the table to renegotiate is quite important, and we've updated our practical law precedents to cover this. Using tools like Contract Express to more efficiently automate contracts, to take some of the burden away from lawyers, is also going to be a smart move to save time. And finally, using our drafting assistant tool, which will automatically check legislative references to take that anxiety away from whether or not you're up to date and you're referring to the right legislation, I think are very important tools that you should be thinking about. It's likely that lawyers will be faced with some level of constraint over their ability to ramp up resources to handle the volume of work that's got to get done, whether that's reviewing existing contract portfolios or renegotiating contracts that are in place. So looking at an alternative legal service provider like the Thomson Reuters Legal Managed Service may be a more cost-effective option for in-house lawyers than perhaps turning to the traditional method of private practice law firms. So perhaps one area of opportunity over the next 2 years is for lawyers to come forward and demonstrate that trusted advisor role by providing value-added insight and updating to clients to inform them of changes that are being proposed and what that means for that business. So a tool like Bulletin Pro, which allows you to gather information and articles that are being published about changes that are taking place because of Brexit, and to tailor that into a specific piece of material that's for a specific industry, is going to be really valuable to allow you to efficiently serve up that insight to your clients.